We figure if we're going to be planning for people and we're doing these other issues, probate and this and that, why not make sure that their asset protection issues are addressed as well? This top one that says the doctor book, that's this. I put one on each table, you can pass it around, we have copies here. We co-authored a book, it's for doctors, but it's not just for doctors. It was targeted for doctors, but there's a lot of information in clear English, easily understandable prose about asset protection.
You know, asset protection, what Joe mentioned before, and he was talking in the context of taxes. When he made the comment, it's not how much you make, it's how much you keep. But having come from the dark side as a litigator, I do see, like, I see the banana peel where it isn't. I see all these dangers lurking everywhere, and there's only so much you can really do. But most people don't do enough. Most people don't do the basics. You can get a little paranoid over this, and you can say, you know, and we may do that as lawyers from time to time. Mark Twain wrote a nice essay, The Danger of Lying in Bed, pointing out all the dangers of being in bed, and that's where death comes in.
Yeah, most people lie in bed, right?
Red knows that one.
So there has to be some balance on this, right? It should be at least discussed so everybody can make their own choice about what they'd like to do on this area, how much they'd like to protect or how much risk they think they might have. Jurisdiction shopping is a part of that. One of the big things in asset protection that we just never seem to get a lot of people, even other attorneys from your past, litigators, you know, to follow, is that there's something called fraudulent conveyance. So I can do just about anything as long as, you know, it's within the realm of being ethical and legal. I can transfer my assets, retitle them, and make it so future unknown creditors can never touch them. But if you're suing me, or I even know that you're thinking about suing me, then I transfer everything so you can't get to it. That's fraudulent conveyance, and I can't do that. And we occasionally get calls from litigators. It's like, you know, I'm representing a doctor or whoever it is, and the jury's out for deliberation, and I don't think it's going to go so well. What can you do for asset protection? The answer is nothing with respect to this creditor. So this kind of planning has to be done before you ever think you need it in a particular situation.
It should not be an event. It's a process. It's the insurance. You don't try to get the insurance. What Steve's talking about is you don't get the insurance after the accident. When you know you've got a creditor or a claim out there. So the planning has to occur before you have that creditor, that doctor. We can do some very sophisticated planning for that doctor, but not as to the patient whose wrong foot he amputated. That's a little too late on that one right there. That would be fraud.